Welcome once again to Lehto's Law. Here's Steve Lehto.
We have an interesting case from the Supreme Court sent to me by Tim and several other people. But we've talked about this before, and this is a situation in Georgia. The state of Georgia's got laws, and they've got law books, much like Michigan has got law books. These blue books behind me are law books. But you may notice that the blue books behind me are published by a company called West's Publishing. Okay, so West's Michigan compiled laws. Those books you can buy from a publisher, or you can go online and see them and read them for free. So the interesting thing is that in Georgia, they had said, well, we're going to give a monopoly to one company, let them publish the books, and we're going to copyright it so that no one else can publish our laws. And the question is, can a state do that? And the Supreme Court now says, no, they can't. So this article here is from the ABA Journal written by Deborah Cassens-Weiss. And the headline says, in unusual lineup, SCOTUS rules that annotations in Georgia State Code can't be copyrighted. And this is the whole thing. Copyright is the idea that if you write something or you create an original work that's a document of sorts, and there's other copyrights, of course, but I'm talking about words. If you create something originally, you can copyright it. But can a government official on government time create an official government document and then say, that's copyrighted? Well, no. So the U.S. Supreme Court ruled 5-4, and I'm scared that 4 justices voted against this. But 5-4, that the annotations in Georgia's official annotated code are not eligible for copyright protection. The court majority included a mix. Chief Justice Roberts wrote the opinion, joined by Sotomayor, Kagan, Gorsuch, and Kavanaugh. The court ruled against Georgia in its suit for copyright infringement against open law advocate Carl Malamud, who posted 186 volumes of Georgia's annotated code to the website public.resource.org. Georgia's official annotated code is put together by the Georgia Code Revision Commission, a majority of whom are state lawmakers. The commission contracted with Matthew Bender, which is a competitor of West's, which is part of the LexisNexis group, to compile the current Georgia code and to prepare annotations. Now, the annotations are the comments below the law. They're not the law itself. The code is the law, but the annotations might say, this is revised from such and such, or this was clarified in this state court ruling, or and have notes to help people use them, okay? So the annotations are beneath each provision. Generally, they include summaries of relevant judicial decisions and also state attorneys' general opinions, along with a list of related law review articles and reference materials. In addition, editors' notes often provide information about the origins of statutory text. The text is then approved by the state legislature. Okay? LexisNexis has the exclusive right to publish the annotated code as long as it limits the price and makes a version without the annotations free online. Okay, so that's the argument. They're saying, look, we make the code available for free, but if you want the annotations, that'll cost you. But the annotations are made by lawmakers. That's the point. Roberts said the annotations can't be copyrighted under the government edicts doctrine, which holds that government officials who speak with the force of law can't copyright the works that they create in the course of their official duties. So it's their job to do it. They're doing it with taxpayer money. They're being paid by us to do their job. They can't copyright that. That makes sense. Roberts said, because Georgia's annotations are authored by an arm of the legislature in the course of its legislative duties, the government edicts doctrine puts them outside the reach of copyright protection. 22 states and Washington, D.C. rely on arrangements similar to Georgia's to produce annotated codes according to the dissent by Justice Clarence Thomas. He said, the majority's rule will leave in the lurch the many states, private parties, and legal researchers who rely on the previously bright-line rule. Perhaps to the detriment of all, many states will stop producing annotated codes altogether. Or they'll continue to do it because they're already doing it on taxpayer dollars. Thomas argued that annotations can be copyrighted, although Congress can step in and change the law if they want to. His dissent was joined by Lehto and mostly joined by Breyer. And then Ginsburg wrote a separate dissent that was also joined by Breyer. The case is called Georgia versus publicresource.org Inc. And, it makes sense, I think, that the government, which is by the people, for the people, of the people, someone once said, is doing work. And when they're finished with that work, the work doesn't belong to them. It should belong to us. That's what they're doing there. This should be relatively simple. I don't know if there's much more to Thomas's dissent other than, gee, the law should be changed if we don't like that, or, maybe they'll stop doing this. I have a feeling they won't. And, the interesting thing is that if there's a market for that information, they can charge for it. That is, someone can do those annotations and add that to the value. And in fact, that's what many of these publication companies do, is they have authors on staff who can do that kind of work. So I didn't think that this was such a contentious issue, but apparently Supreme Court 5-4. So 4 justices actually said, you know something? Government workers can create stuff while we're paying them to do their job, and then they can copyright it and charge us to look at it. Does that really take that much thought? And, it's a common question I get asked all the time is, I do a lot of writing. I write a lot of books. And oftentimes in my books, doing research, I encounter documents, okay? And I want to quote a document. And there's all kinds of issues regarding fair use, about whether you can quote a piece of a document, the whole document, and so on. It's not uncommon that I encounter a government document, okay? And a government document. And it's a government document. So it's generally not copyrighted, and I can use the whole thing wholesale if I want to. And I've been trying to think now while I'm talking here. I could have put some more thought into this before I started rolling the camera, but I knew it would come to me. And I'll give you an example of a document that I came across. If you watch the movie Tucker with Jeff Bridges by Francis Ford Coppola, at the very, very beginning of the movie, it says that Tucker made these gun turrets that were used in bombers in World War II. And those gun turrets were widely used and helped us win the war. And that there was some kind of raw deal that Tucker didn't get paid for them. And the story's not true. It's just not true. And it's interesting because I tried to track the story down. I was hoping it was true. I wanted it to be true. It'd be cool if it was true. And Tucker did design and patent a gun turret, but it didn't get used. And the reason I know that is that I was digging through some archives someplace, and I came across a declassified government document. And after World War II ended, one of the things that we did is we actually had people go in and create reports to try to figure out what we did right and what we did wrong during the war. And there was a lot of issues with procurement, that is the government buying stuff. And, much of American industry got mobilized to go to war. And the car companies started building weaponry, for instance. And so there was a whole process involved where these companies were building airplanes for the government. And the process by which that happened had to be studied to see what went right, what went wrong. And so one of the things that happened is they actually deconstructed the whole process, in particular with bombers. And bombers had gun turrets on them. So there was a time in the early 1940s when everyone knew the government was going to start building war machines. And some of the things they're going to build, you wouldn't have to build the whole thing. You could get a contract building just machine guns, or making just ammunition, or just gun turrets. And so gun turrets were something that people knew about, but there was some debate on which designs were best for the gun turret industry. And Preston Tucker came up with an idea for a gun turret that he liked, and it was a motorized with electric motors that would allow it to rotate and allow the gunner to move and so on. And he patented his gun turret and built some prototypes of it. And he actually got some people from the U.S. Army Air Force to come up and take a look at his gun turret. And they looked at it and said, that's interesting. He demonstrated it for them. And so they actually had a series of demonstrations held down at the air base in Ohio. And they invited Tucker to come there and bring and demonstrate his gun turret. And he demonstrated his, and the competitors demonstrated theirs. General Electric, Westinghouse, Rand, Sperry, huge corporations, and then Preston Tucker, Ypsilanti Machine and Tool. And when all the dust settled, they hired a bunch of these other companies, but did not hire Tucker. And if you go and look through public records on what happened, you'll see news stories that simply say that Tucker demonstrated his gun turret and nothing ever really happened. And then years later, he would tell people, yeah, they basically, he led people to believe that he'd been ripped off or that he hadn't been treated fairly. And that story spun into they stole his designs or they used his designs without paying him. But if you go through the documents I found a declassified, previously top secret document that said that at that meeting in Ohio, where they had all the demonstrations, they sat down and discussed amongst themselves, not with the vendors, but amongst the brass, the generals and so on. They said, okay, here's the deal. We're going to be building thousands, if not tens of thousands of aircraft that need gun turrets. And we'd be best served to standardize this as much as possible, to not get parts from 5 or 10 different companies, but to get parts from one company that can crank out a boatload of these things. Because if we standardize it that way across many platforms, it'll be easier for everyone. It'll be easier to manufacture them, easier to service them, easier to train guys to work on them, all kinds of things. And that would be good. And so they looked at all the designs in front of them and they looked at the pros and cons of all of them. And one of the things that really hurt Tucker was he was representing a very small company in Ypsilanti that basically nobody had heard of before outside of Ypsilanti for the most part. And so when they looked at Tucker, they said, his design is interesting. His design is interesting, but we don't think he's got the manufacturing capability to build enough of them for us. And by the way, for the car guys in the audience, you'll know that pretty much the same thing happened with the Jeep design that Bantam came up with and Ford got to manufacture. But it's a little different because nobody took Tucker's design and manufactured it. They just simply didn't give him the contract. But the point is, he didn't lose the contract because the design was no good. He lost the contract because they looked at him and said, there's no way that you can tool up to build as many as we need. So whether they told him that or not, I don't know. The report didn't say. But the report did say specifically that at this demonstration were 4 or 5 huge corporations and Tucker. And they looked at all the turrets and they were all pretty good. They picked a couple winners, but Tucker didn't lose because his design was no good. He lost because he didn't have the manufacturing capability. So I discovered that document. It's a declassified United States government document. And it's a government document. It's not copyrighted. I could reprint the whole thing if I wanted to. Didn't need the whole thing. Just used a little portion of it. But the point is, as a government document, I don't even need to worry about it. I don't even need to worry about it because it is not copyrighted. It is something I could just use willy-nilly if I wanted to. So there you go. Interesting case. I think it came down the right way. I just was surprised at a 5-4 vote. So there you go. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. As you wish.